Specially called meeting of August 6, 2015. I'm John Michael with the Metro Department of Codes Administration, and along with Rick Harrison from the Metro Codes Department, we'll be presenting the cases to the board for today's review and today's public hearing. The procedure will be for us to present the case record. We'll present the site plans, photographs, and maps of the properties that are involved in today's cases. Also, the board will be presented with any letters or emails that we've received in support or opposition to any particular case, as well as any correspondence we receive from other government agencies involved in the decisions. At the conclusion of today's presentations, the appellant will present their case to the board, along with any persons in support. If there is in fact opposition to a case, the board will then hear from those parties, and after the opposition has presented their testimony, the appellant will have a period available for rebuttal testimony. The board, in its rules, provides that an appellant in cases with opposition 10 minutes for the applicant to present their case. In a contested case, the board provides 15 minutes for each side to present their testimony. Should the appellant wish to provide rebuttal testimony, then he or she would need to reserve some of their allotted 15 minutes to do so. All section numbers that we refer to today come directly from the Metropolitan Zoning Code, which was adopted by the Metro Council and became effective on January the 1st, 1998, and applies to the entire jurisdiction of the metropolitan government. I will introduce and make part of the record the entire zoning code, and will dispense with the reading of individual sections unless the appellant or opposition requests their reading into the record. The Metro Zoning Code requires that these proceedings be taped. Therefore, it is imperative that anyone addressing the board or speaking from the board come forward, speak into your microphone after identifying yourself, and then make the presentation. It should be noted that if it's found that anyone has presented false or even misleading testimony to the board that would have affected the board's decision, any approval may be revoked at a later date by means of a show cause hearing. The board will go through the cases that are set for public hearing today, and after each case, the board will discuss and vote on that individual case. The board is vested with the power to act on these cases before us today under the following provisions as outlined in the Metro Zoning Code, specifically Section 17.40.180. The code requires that 4 members of our 7-member board be present to constitute a quorum. At this hour, we have 6 members present and can proceed. Additionally, the code requires 4 affirmative votes to grant an application. In the unlikely event that there are only 4 members present and that there are not 4 affirmative votes, the application shall be re-advertised for the next available public hearing cycle. In the event that there are 5 or more members present, but not 4 affirmative votes, the case will remain on the board's agenda for the next 30 days. Applications that fail to receive 4 affirmative votes within 30 days of the public hearing shall be deemed denied by operation of law. The appellant or any aggrieved property owner may request a rehearing within 60 days of this public hearing. Further, the appellant or any aggrieved property owner may also appeal the board's decision to Chancery Court within that same 60-day period. After that time has elapsed, the board's decision becomes final and no further action can be taken. If you are an appellant and your case is granted, it will be necessary for you to obtain the permit for which you've applied. It should be noted that a permit must be obtained within 2 years of board approval in order to remain valid. Today, Mr. Chairman, I submit that all cases have been filed in the proper order, that all appellants have been notified by certified mail as required by code, and all affected property owners have been notified as required as well. Seeing no elected officials or almost anyone other than the appellants for today's board meeting, we'll dispense with any further recognitions. Note that by way of preliminary announcement, our next board meeting is scheduled for September the 17th, 2015 at the regular 1 p.m. start time, and very importantly at our regular meeting location, the Sunny West Conference Center in the Howard School Building at the Metro office campus on 2nd Avenue South. Just as a formality, is there anyone present in opposition to either of today's cases? Seeing no indication of any opposition, we'll note that the board, of course, has a consent agenda. A board member reviews the record on each case prior to the hearing, and if in their opinion the applicant meets the criteria for the application requested, and they feel testimony in the case would not alter the material facts, that they recommend the case to the remainder of the board for approval. At this time, I defer to the chairman with regard to the possibility of consent agenda for the 2 cases today. Actually, I guess I need to present the actual 2 cases specifically so you can identify them. The first of the 2 cases is case number 2015-52 from Council District number 5. The appellant, Bernard Wilson and Harry Shields, owner of the property located at 213 Neal Avenue, are requesting a special exception from the required street setbacks from 30 feet down to 10 feet in the RM20 zoning district in order to construct 2 duplexes. The matter is referred to the board under section 17.12.035D1 of the Metro Zoning Code. And the appellant has alleged that the board would have jurisdiction under section 17.40180 subsection C for special exception. The second case, case 2015-67 out of Council District number 8.
John Michael, can I jump in for just a second?
Yes, Mr. Chairman.
That one being on the consent agenda is conditioned upon the Planning Commission's approval with conditions. So I think the conditions that were on this, true? Okay. So anyway, for the members of the board, it's with the Planning Conditions approval conditions.
Yes, and Mr. Chairman, I believe that Planning Commission Planning Department feedback is included in the packet for all of our board members and was among the late documents received, and obviously we're delighted to have that. On the second item, case 67, Henry Watkins, the appellant, and Brian Watkins, owner of the property, located at 243 Broadmoor Drive, are requesting variance from the setback requirements in the RS10 district in order to construct a new single-family residence. The matter is referred to the board under section 17.12.030A. The appellants allege that the board would have jurisdiction under section 1740.180 subsection B for variance. And those are the items that I believe have been reviewed and considered as possibilities for the consent agenda.
Okay, so we have a motion for the consent. Is there a second?
I'll second.
Okay, we got a motion, a second. All in favor? Aye. Any opposed?
Actually, I had a discussion point for for case 52.
Okay.
The Planning Commission's recommendations. I'm comfortable, and I'm certainly willing to vote against it for this, but I'm okay with the first 3 recommendations, but I don't really feel that it's appropriate for us to enforce the 4th recommendations, which are generally aesthetic issues. And I feel like that if the Planning Commission wants those things, that needs to be codified and not really left up to another board to enforce for them, if that changes anybody's motion.
I mean, the only thing I would say is that this is a case that had substantial opposition before, and I think that the appellant has done a super job of working with planning and working with the neighbors, and if this is a condition that's come out of that and the appellant agrees to it, then...
Well, I'm fine with the appellant voluntarily doing that, but I don't recall any of that being discussed in any of the opposition, any of the aesthetic issues. So I would not be willing to vote for the motion as posed.
So are you saying you would vote for 1, 2, and 3 to be included?
Sure.
I'd agree with you on that.
For instance, one of them is building elevations for the street-facing facade shall be provided with the building permit. The following standards shall be met. And then C, under 4, says EIFS vinyl siding and untreated wood siding shall be prohibited. I really don't understand how that has anything to do with us. I don't know why. I can understand them, for whatever reason, not wanting untreated wood, but cedar is a perfectly viable building material and high quality. So I don't even know why we're getting into that. I don't really feel like it's our purview.
I think it's a question of if that's in the zoning code or not, and if it's not, then I don't think we should rule on it.
I agree. I mean, if it's in the zoning code, then it doesn't need to be said. Just like we don't have to tell them to follow the fire codes.
Toward that end, and I'll be quick to defer to the zoning administrator if he views this differently or wishes to chime in differently, aesthetic issues are typically not governed through our Board of Zoning Appeals. It doesn't mean they're not governed, it just means they're not typically governed by this. Therefore, the special exception need not necessarily include that specification, but I don't know that it rises to the level of being harmful to include it. So the board has certain discretion there.
Being the ever-practical human I am, does anyone object to deleting the condition, the fourth condition of the planning department's proposed approval?
The entire part of number 4?
Yes. Hearing none, the consent agenda is modified that we would approve the case based upon the conditions 1, 2, and 3 of the planning department's proposed approval with conditions. So we have a motion. Is there a second? Got a motion, got a second. All in favor? Aye. Any opposed? Passes.
This concludes the Board of Zoning Appeals meeting for August 6, 2015. Again, we'll reconvene on September 17th, 2015. Thanks.